The Illinois Sheriff's Association sounding off on a measure that would prohibit police from pulling people over for a host of violations, including speeding, including tinted windows, or improper lane usage, or not wearing a seatbelt, having a defective bumper, broken mirrors, bad lights, a whole host of different moving infractions. And this measure apparently is not going to go anywhere. And the sponsor, Justin Slaughter, Democrat member of the House of Representatives for Illinois, telling several outlets, including constituents, that he's not moving forward with this. So let's go ahead and get on into it. Bishop on air with you here each and every weekday morning with the live stream, and we segment things out throughout the day. So I appreciate you guys being here each and every weekday morning. But let's go ahead and let's tap into a conversation I had with the Illinois Sheriff's Association president, executive director, rather, Jim Kaitschuk, and had this conversation with him after yesterday's show. And asked him about this legislation and whether or not this is going to go anywhere. Here's the executive director of the Illinois Sheriff's Association.
Well, obviously, when I read this, it made me turn my head a bit to say, I can't believe I'm reading this right now. Because, I mean, the way that this was written, as you well know, based on the reading of the bill, I mean, the synopsis covers it for rarely does a synopsis usually cover the bill pretty well, but in this case it does. So in essence, somebody could be going up to 25 miles an hour over the posted speed limit, and we couldn't stop them. That's not a primary reason for us to stop the vehicle. You think of the number of accidents in a school zone, in a residential area, kids out playing basketball, whatever the case may be. I mean, that's just, I don't even understand the base for wanting to put something like that out there. I think even more disturbing, though, was when I learned that the bill was being proposed by the Cook County State's Attorney's Office. So Kim Fox, her last year in office, is going to propose something like this. Just doesn't make any bit of sense to me from a prosecutorial standpoint how you would want to do this. And it's my understanding, I certainly don't want to speak on behalf of the state's attorneys, but I don't know of another state's attorney in the state that would be supportive of a measure like.
So talking with the executive director of the Sheriff's Association, he had said he talked to Justin Slaughter yesterday morning before I chatted with the executive director. And I asked, is this like just a conversation starter? Is it like a coffee table book type thing? Like, here's all the things that are causing problems with certain communities and why they get pulled over so much, and why don't we just limit the ability for police to pull people over? And it's not just that, it also essentially spelled out that any evidence of a crime other than what they got pulled over for, if the predicate was one of these issues, that evidence in another crime could not be administered in court. So that was yet another interesting little bit of that proposed bill. But Jim Kaitschuk, executive director of the Sheriff's Association, saying that from his understanding, this thing's not going anywhere.
Well, I think he indicated to me, he called me this morning and indicated that this bill was drafted significantly more broadly than he ever intended to. He, quite honestly, he said, I take ownership of that. It never should have gotten out like this. There should be conversations. But this is way too intrusive of a bill for us to move forward. So it's his intention not to move the bill. He even discussed the possibility of tabling the measure. So I think that's good news. He assured me that this is a bill that will not move this spring session. He indicated that there may be talks in the future, about some of the other pieces and provisions of the bill that are less, that he would view as less egregious from a traffic stop basis. For example, maybe you mentioned window tint as a possibility. I don't want to speak for him on that, but he talked about the pretextual items. And just so you know, his basis, or the basis for the legislation, was the traffic stop study information that was put out in an article, I think probably about a month ago, in the Chicago Sun-Times regarding racial disparity in traffic stops. And, I talked to him about that too. He indicated that, he said, even the study, may have some faults in the study. So before we move forward on anything, if in fact there was going to be a move forward on anything, on his part, by the way, I'm not agreeing here at the Sheriff's Association that any of these changes should be made. In fact, our position has been and will be moving forward that we're opposed to this measure, regardless of the modifications that would be made to it. So, but at least, I appreciate his willingness to accept it, to give me a call and acknowledge, that the legislation is not well written, to say the very least, from his perspective, and it's not going to be something that moves forward.
So again, Kaitschuk saying that he fully anticipates this thing is stalled. It's not going to go anywhere. And even Justin Slaughter providing similar types of comments to other publications as well. And I did have somebody send me a Facebook chat that they had with the representative indicating their displeasure of such a bill. But the representative replying saying that it's not going anywhere. It's really just a way to start a conversation. More from the executive director of the Illinois Sheriff's Association.
See less pieces of substantive legislation move through the process. With that level of expectation and the fact that we've got minimal time that's going to be occurring in the General Assembly before March 19th, which is the primary, you've got 2 months where I guess a lot could happen, but I don't know that I would expect a lot to happen this year with regards to pieces of legislation moving through. As far as things that we've got, we've got some issues that, obviously we would like to take a closer look at the list of detainable offenses, and more specifically those offenses that are not detainable. However, I don't know that there's going to be enough information available to everyone involved by the point in time where we get through the legislative session to make substantial changes to the Pretrial Fairness Act and what we.
And again, Kaitschuk talking about the upcoming legislative session, and of course, with Slaughter's bill not going anywhere, what about changing the Pretrial Fairness Act? What about changing the Safety Act, the measure that's eliminated cash bail across the state? You still see stories regularly of people who are arrested and then they're let out, and then 5 hours later they get arrested again, and so on. You've got even migrants committing crimes up in the Chicagoland area that they're being arrested and then they're being processed and let out. More from Jim Kaitschuk.
We can detain people for. Obviously, there are other provisions within that where I think we would be very supportive of additional opportunities for the judges to make decisions and additional authority for them to be able to hold people that is not available to them today. I think we're going to see more of that. But the body of work, we're talking about 3.5 months that we've had for the Pretrial Fairness Act. So I don't know that we've seen everything come into full fruition in terms of changes that we would like to see made. And
those changes could be debated as the spring session goes on. They're coming back next week, by the way, Tuesday, February 6th. State legislature returns to really get into spring session. So will the Safety Act and any changes that may be needed be brought about? Will the Pretrial Fairness Act be amended at all? Will there be those types of conversations? Again, more from the executive director of the Illinois Sheriff's Association.
And I think it's challenging because what we see is a lack of one of the things that was in there. We've got repeat offenders. I'll give you that example. Let's say that I've got somebody that is a repeat offender that's arrested for retail theft. They're processed in, processed out pretty quick, right? They immediately go back, shortly thereafter and have another retail theft. Could be the next day, whatever. And again, they're processed in and released out the back. The challenge here is because at the back end of this, while you could, potentially they would be violating their pretrial release conditions, there is an opportunity to hold, but you have to prove that any less detention or that detention in a jail is necessary to get them to stop doing those things. And you have to show that they are a threat to the community or themselves, and you have to show that they are a willful flight. Those parameters placed on this make it very difficult for both the state's attorneys and for the judges. That's a conversation that to me is not necessarily, people are it's being misrepresented in some cases. And what I mean by that is, yes, I know people are using it when it works well and not using it when it doesn't work well. I want to look at things as much as possible as when can we detain somebody? Because there are opportunities even under cash bail. If you had somebody that you wanted to hold in custody, one of two things could happen, right? You could set the bail at such an amount that would be unachievable for them, or you could have set no cash bail. So there was an opportunity for that then. I think what we need to do is we're trying to level this up on a detention basis under the elimination of cash bail to make sure that the more of an opportunity to hold people exists than does today. And I don't think that we have that level of freedom for judges to be able to make that determination. So That's one of the big things that we're looking at. And judges previously could have done that on any offense, and they really don't have that opportunity now because there are only certain offenses that are already taintable. So we're learning as we go, Greg, and I think we'll continue to learn, and there'll be, continue massagement of the Pretrial Fairness Act moving forward, but I don't know exactly what that looks like.
So again, Kaitschuk sharing with us some of the thoughts he has, not just about Justin Slaughter's bill, which he says is not going to go anywhere, and you're seeing more and more publications write about this now, but clearly it's stalled out. But could you see little tidbits of it come out? We'll, of course, track that throughout. But, of course, you also have the other criminal justice issues like the Pretrial Fairness Act and the Safety Act. So all these things likely going to be debated as the Illinois legislature returns next week. Appreciate you guys being here. Be sure to like, subscribe, hit that notification bell, and follow along. Bishop on Air, anywhere.